All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Friday, March 15th, 2024. We're working off of voting list number 13. And start up. We're going to start off with Senate Bill 471.
Senate Bill 471 is an administration bill that makes numerous changes to statutory provisions regarding victim compensation awarded through the Criminal Injuries Compensation Board, or CICB. The bill alters membership and composition of CICB, along with its duties, powers, and procedures for CICB to make awards to victims of crime. It also alters the statement of legislative policy regarding CICB, expands the eligibility for, amount of, and types of awards CICB is authorized to make to specified victims of crime, and finally authorizes reconsideration and judicial review of CICB decisions. The bill also authorizes the governor for fiscal 26 and each year thereafter to include in the annual budget bill an appropriation to the Criminal Injuries Compensation Fund that is adequate to ensure a balance in the fund. There is one amendment in your voting packet. It is Amendment 633-420/1. That is Amendment 633-420/1. The amendment pertains to CICB delegating duties to its employees. I did want to note there had been a fiscal note on it, but I believe we have, and let me just confirm. We had gotten clearance from B&T.
All right, I would like to move the amendment. Second. All right, now the bill is before you as amended. Further discussion. Motions for favorable. It's been seconded. All right, Senate Bill 471 with amendment passes unanimously. Senate Bill 538.
Senate Bill 538 repeals the limitations on non-economic damages in civil actions for personal injury or wrongful death and related provisions. The bill does not alter the caps on damages in medical malpractice cases, which are addressed in a different statute. The bill applies prospectively and may not be applied or interpreted to have any effect or any application to any cause of action arising before October 1st, 2024. There were amendments that were discussed to not eliminate the caps on non-economic damages, but rather to raise the caps from $935,000 to $1.75 million with a $20,000 per year escalator.
Right. Further discussion. Is there any discussion? So, sorry, Senator James.
I got a chart of all 28 states that have caps that are similar to ours. As of March of 2022, just because I wanted to see what was going on around the country. Oh, and actually this is in healthcare, which I think is a very unique and often much more likely for there to be some injury. And all I just wanted to make a comment about was that, just don't want to misspeak here, but based on my review, there is no state that has a cap anywhere near that high. I think there's some that are up in the 750,000, maybe 850,000 range. So I just wanted to sort of let the committee know that. But I will also note there's 5 or 6 states that do allow for a different kind of inflation indexing that I think is smart, tied to some form of the inflation as opposed to some arbitrary number that I think is what we ended up sticking in the statute. So I just wanted to point that out to people. Maybe that'd be helpful in the discussion. Thank you.
Excellent. Thank you very much. Senator Walstreicher.
So I just want to take a step back and talk about how we ended up here with the caps. And I'm going to vote for the bill, and I support it, and I support the compromise that we've landed at. But I'm worried that we're kind of anchored to the previous caps, and I want to just explain why they're inappropriate, because I've done a tremendous amount of research over the past few weeks. And none of this research relitigates some of the issues we were talking about with Senator James and her experience here during the time. So this isn't designed to relitigate that. So, but I think it's important to understand that kind of why these caps got into place and why they may have been kind of very time specific, may no longer be appropriate even as we're voting to increase them. So a lot of this comes down to how insurance companies make their money. And this isn't a pejorative description. Private companies should be able to make money, but we often forget about how insurance companies make their money. So insurance companies make their money in 2 ways. The most obvious way is the one you think is how they make their money. They make their money based on premiums paid in, and presumably they're judging risk and they're paying out claims at a lower rate than the premiums that they take in. And they make money on the difference between those premiums and the claims. What people often forget is that the difference in that money just doesn't sit in their bank account in case there's additional claims to be made. Insurance companies are investment companies, and the difference between the premium and the claims is called the float. And the float is really where insurance companies make their money. And there's nothing wrong with that. That's how they should make money. So they take the premiums that we buy from them, and they take that money and they invest it. And they invest that money. And so they're making money off of the premiums, and they're making money off the float. And so in the late 1970s, there was incredible inflation. We think inflation is high now. In the late 1970s, there was inflation unlike we've ever seen before in the United States within modern times. And so the Federal Reserve raised their rate beginning in the early 1980s to crack down on that inflation. My parents tell me a story. They bought a house in the early 1980s. Their mortgage was like 18%. Some crazy number like that, because banks had to loan at a high percentage because the rate was so high. And so when the Fed rate was upwards of 17, 18%, what that meant was for insurance companies is that they could make a lot of money by not doing much with their float. They could basically take the float, put it in the bank, and get 18%. That's an incredible return for not a lot of work or not a lot of risk. What that also meant was that they could keep premiums low, because when insurance companies make money in 2 different ways, off of the premium and off the float, and they're making a lot of money off the float in a high interest rate environment, it meant they could keep premiums low. As inflation came down, the Fed rate came down. In other words, the interest rates that banks were paying out was coming down simultaneously. And here's what that meant. It meant insurance companies in the mid-80s had to start raising their premiums because the return on their float was becoming less. It wasn't because suddenly there were a lot of claims in the mid-80s. It wasn't because there were a lot of runaway juries that started all of a sudden in the 1980s. It was simply macroeconomics. Rates were starting to go down after inflation was in control, and that meant insurance premiums had to go up to make up for the lost float that the insurance companies had. And that's all economic players acting rationally. But the legislature responded as premiums went up by capping these judgments. And it was designed to help with insurance rates in a very specific moment. If we had not done the caps, we probably would have gotten out of that moment because insurance rates stabilized. And so we're anchoring this to the caps. And I understand we've come to a compromise and it's something I support. But I just want to make clear that the original reason that we put these caps into place is no longer in effect. And only 10 states did this. So there are 40 states, red states and blue states and purple states and everything in between, that have no caps outside of the medical world. And so we are raising our caps in the compromise bill. Again, I support that, but we're not getting yet where we need to be, because there are other states that do this in a way that doesn't limit the recovery of victims of bad acts. So with that, Mr. Chairman, thank you for the explanation.
Very brief. I don't believe we have the amendments, and so there's nothing to look at.
Yeah, so, we'll offer the amendments in a second. Do you want to, because if you'll just hear them possibly want there's too quick of a turn on this to have it on right, but Senator, same question. So Maury has the amendments that were entered in late, so impossible for council to turn them back quickly enough. But you'll have an oral explanation in just a moment. Would you like to hear that, or you want to speak on the bill? Okay.
Numbers. I note that if the base that we're starting off with anew is 1.75 million, that $20,000 a year as an escalator works out to 1.1%, which is far less than inflation. And my concern is if we go with these numbers, we're going to end up in the same position a couple of years from now that we are now. The people are going to come in and they're going to say that we haven't kept pace with inflation, that we have to once again raise the escalator. And let's not raise it just the inflation adjusted amount. Let's raise it a lot more. I want to make a counter proposal. So if we go back to the $500,000 back in 1994, when the amount was adjusted, and we apply the inflation adjuster since 1994, we would be at $1,020,000 today. So I'm throwing out a number of $1.2 million, which is higher than it would be, considerably higher. But I'm also suggesting a 3% annual rate of inflation, and just apply the 3% each year to whatever the new higher amount was from the last year, 3% a year. If 3% is a $36,000 annual adjustment rather than $20,000. So we'd start the base at a lower amount, but we would adjust it annually more or less consistent with what inflation has been long term. So we're not going to be in this position 3 years, 5 years from now, where the plaintiffs' lawyers are going to come back again and say we've fallen behind. Hopefully, this can be a long-term solution. And a $36,000 escalator is a whole lot more than the $20,000 that you're proposing. So it's a lower base number, but a higher escalator amount on an annual basis.
All right. Well, Shamar, let's hear the first proposal first, which is what 1.75 and 20%. Shamar, if there's anything else you need to add to that?
So this won't be the exact language, but it'll be something along the lines of the limitation on non-economic damage provided under subparagraph I of this paragraph shall increase by 20,000 on October 1st of each year, beginning on October 1st, 2025. The increased amount shall apply to causes of action arising between October 1st of that year and September 30th of the following year inclusive. And then above that, we would either add another subparagraph, and it would say something to the effect of, except as provided in paragraph 3, II of this subsection, in any action for damages for personal injury or wrongful death in which the cause of action arises on or after October 1st, 2024, the effective date, an award for non-economic damages may not exceed 1.75 million, excuse me, or 1.2 million, whichever amount you all decide.
All right, so let's talk about and consider that amendment more first, and then we can go to jump over to Senator West's amendment if the amendment fails. So slightly more generous increase and a more predictable escalator, though maybe percentage wise less over the course of time, maybe. But a more predictable escalator, understanding that rates of inflation change from year to year. In the last 3 years have been drastically different than they were in the prior 7 years. So we can run that amendment and then see how it goes. And then if not, we'll open it up for further discussion with Senator West's amendment. So the motion for that is for favorable. We can take a roll call if you like.
Vice Chair Waldstreicher,
Yes.
Senator Sidnor,
Yes.
Senator West,
No.
Senator Muse,
And hearing the history of that and understanding it a little bit differently than what I did, yes.
Senator Folden,
I think I missed something. Are we voting?
Just the amendment to do the escalator at 1.7. I'm sorry, the new caps will now be at 1.75 million, and the escalator annually will be at 20%. That's
20,000.
20,000. Yes, 20,000. Yes, 20,000.
Oh, okay. So he just presented.
20% of 1 point. Good. Yeah.
So his presentation was not what we're voting.
No, that's right.
Okay. No.
Senator James,
No.
Senator Charles,
Yes.
Senator Kelly,
Yes.
Senator McKay,
Nay.
Senator Carter,
Yes.
Chairman Smith.
Yes. Now the bill is before you as amended. Further discussion.
So we're not considering that as an amendment. I just want to be clear. I thought I heard an amendment offered. Okay. Oh, okay. Okay, thank you.
Motions for favorable with amendment. Roll call.
Vice Chair Waldstreicher,
Yes.
Senator Sidnor,
Yes.
Senator West,
No.
Senator Muse,
Yes.
Senator Folden,
No.
Senator James,
No.
Senator Charles,
Yes.
Senator Kelly,
Yes.
Senator Carter.
Yes.
Oh, sorry, Senator McKay. Sorry.
We know where you.
Nay. Nay.
Did you just record the?
Nay, nay.
Right.
Oh,
Yeah, we're gonna go to 11 and then
Chairman
Muse
Smith.
and then you're, yes. Senate Bill 538 passes with amendment
7-4.
7-4. All right, we're now gonna move on to Senator Carter, Senate Bill 11. And then we're gonna go to Senator Muse, and then we're gonna go back to Senator Carter.
Senate Bill 11 repeals the current prohibition on expungement of a charge within a unit of charges unless all of the charges in the unit are eligible for expungement. The bill authorizes the partial expungement of eligible charges within a unit if one or more of the charges is ineligible, and establishes procedural requirements for partial expungement under 10-105 of the Criminal Procedure Article. There is an amendment in your voting packet. It is Amendment 873-324/1. That is for Senate Bill 11. And Amendment 873-324/1. The amendment strikes provisions of the bill as drafted and provides in uncodified language that the Department of Public Safety and Correctional Services and the Maryland Judiciary may not engage in any procurement related to the central repository, the judicial case management system, or any successor database that serves the same purpose as the central repository or judicial case management system, including procurement of information technology services, supplies, software, or equipment that is not compatible with the partial expungement of charges within a unit of charges. The bill specifies, or the amendment specifies rather, that for the purposes of this section, partial expungement means the ability to expunge a charge or conviction that is eligible for expungement when two or more charges arise from the same incident, transaction, or set of facts, and one or more of the charges are not eligible for expungement under Title 10 of the Criminal Procedure Article. As a technical matter, I would note that because this is an ongoing requirement, it may actually make more sense to codify this provision if the committee intends to move on it. And Department of Legislative, if you'd like to do that, DLS can find a place in the code for it.
That's right.
As long as we can spend it in your part of the-
Well, let me ask you for a minute how this is going to work. So this bill's been before us for several years running. And I can remember in prior years' testimony to the effect of expungement not only means deleting information that is computer accessible, but also would include going through the court files and expunging in cases where you have an expungible offense and a non-expungible offense, that you'd have to go through the individual court files and expunge testimony, entries, etc. It was going to be extremely expensive. So what are we talking about here in terms of expungement? Is this merely expunging stuff that's available online on the computers, or you're talking about more extensive expungement than that?
I think that the simple answer to the question, Senator, is that the amendment language itself actually doesn't require expungement of any records. What the amendment is doing is saying that DPSCS and the judiciary couldn't engage in certain procurement related to those systems for record keeping, unless what they were procuring was compatible with partial expungement.
All right, so there's no obligation for the judiciary to go behind the information which will be accessible to the public online.
If I'm understanding you correctly, I would say no, it doesn't change anything as far as what they are required to do by law with the case records that they currently have. It's related to new technology that's laid out in the amendment and procuring that.
Okay, and then last question is, the judiciary has always been very opposed to this.
To the concept, but now the bill is just
Right.
Yeah.
Has this amendment been run by the judiciary to get their, it's only 2 paragraphs, to get their reaction to it, to see whether with this language, they would be signed on as favorable, or would they have some opposition, which we're not aware of, that we should be aware of before we pass the bill?
Sure, I can just speak for myself. I have not spoken with anyone
have
from
you?
the judiciary.
with judiciary. Have you spoken with judiciary about putting it on a couple bills?
I have not had any one-on-one with the
Thank you. I'll be really brief because I'm anxious to get this voted. It's not what we wanted, but Senator and everybody, if you were here, we talked about the fact that this bill has been punted around for 20 years, because the judiciary is saying they don't have the ability to do it. And now what we are doing here is the major concession of life by saying that all we're requiring is that whenever you do procurement for new technology, you must have whatever you procure, you must have the ability to do this partial expungement. So I agree. It is not necessary to run it by them. They've been the block in the road for 20 years to this because of claiming of an incapacity to do it. So it's a weak bill, but at least we're making progress and I'm good with it. So I'd like to move it. Thank you.
Yeah, and just a quick thank you to the sponsor. The sponsor and I have been partners in crime on expungement for almost 20 years now, and we've been batting this around. And when I heard of this idea, I was like, wow, I can't believe we didn't think of this earlier, because it's incredibly graceful and elegant, by essentially requiring them to have the systems to do this. It allows us to come back when those systems are in place to require it. The judiciary has never been ideologically opposed. These particular convictions are already eligible for expungement. They just have a tough time doing it within their current information systems because it's commingled with other offenses that are not eligible. So anyway, it's really an elegant place to be that we're landing here. And I want to thank the sponsor for her hard work and the advocates who got us to this point.
Thank you. So we're taking this bill off of an idea that in the future, when it's available, we're going to pass a bill that says you need to incorporate this and you need to buy it and make this ability. But we don't know when that is. We don't know when they're updating their systems, right? And then we're also have charges that we're going to be able to partially, from a group of charges, expunge, and thereby removing some of the data that's maintained of these offenses, because if it's expunged, some of the documents associated with the larger charge could be affected by this. Is that correct? Be redacted. So we're literally changing the dynamic in which we have an offense or a series of offenses that occur, that some are much more higher or more egregious in nature, but we're going to allow them to, we're trying to find a way, which isn't available now, and we're going to vote on it now, but we're in the future, we're going to make them do something that would cause redaction and potentially cause issues for future people that would see these appeals in the future. We would literally be redacting information that's critical to the crux of the case. Bueller? Anyone? No, I'm looking for a response.
Say ends.
So, okay.
In conclusion?
No, that was my question is, so we're allowing this to happen. That's going to cause issues for state's attorneys or in the future, the judiciary to be able to make proper decisions or dispositions because some of the critical information regarding the case is going to be redacted, which ultimately this play could result in the loss of some of that data or that information, which would allow for potentially other parts of elements.
So there's a bill before this committee right now that's called a good cause expungement, and that way a court could look at the whole situation and make a decision, right? But we're not passing that bill. That's not this bill. Partial expungement is a bill that's been around forever. The bottom line is this: if someone is not convicted of something, they should not be blocked from expunging it because they had a conviction on another thing that was charged at the same time. This is something that we should do because we now allow felonies to be expunged in some situations and a multitude of other arbitrary crimes. All this is the last vestige of non-convictions, and allowing for that expungement. I don't think it's a valid argument to say that this one category of non-convictions should not be expungible when we let serious actual convictions be expunged.
Well, not through my doing. I mean, this is the common practice here. This body wants to remove charges of people's ill doings towards the community that at large. And then here we have probation before judgment, or whatever you want to say, or non-convictions, because the state's attorney has so many charges on them. They'll just be like, well, that's the non-conviction. We'll dismiss this, but we're going to basically charge under this one to work a deal out with them. And then I'm done. Thank you.
Senator West, and then we're gonna move on to the dime, off the dime on this one.
Thank you, Mr. Chair. So two things. I think this is probably the best solution we can come up with under the circumstances. But before we pat ourselves too much on the back for this elegant solution, does anybody have any idea how long it's going to take before the expungement, if we pass this, before partial expungement will be possible? Are we talking about 3 years, 13 years, 23 years? We're flying blind. And then the second concern I have is the actual language of the bill, which says the judiciary may not engage in any procurement related to the central repository, including procurement of supplies or software that's not, or equipment. Suppose a piece of equipment that's part of this large system they have wears out, and a piece of equipment has to be replaced or the whole system is dysfunctional. Does this require them to not buy that piece of equipment, but rather buy an entire new system in order to comply with this law?
I think it's an interesting question. My read of it is that if the piece of equipment that is broken and needs to be replaced is not compatible with partial expungement, then they could not buy that piece of equipment.
How about supplies?
I think based on the reading of it and sort of taking a broad view of the language, if there's something that has nothing to do necessarily, that whether you pick widget A or widget B, it has no bearing on whether or not it is geared towards partial expungement or the unit rule. Then there's no issue there. You could pick from widget A or widget B. It's that because both are compatible with partial expungement, it makes no difference whether you pick one or the other.
Okay, well, here's my concern. For as long as I can remember, the judiciary has been steadily migrating from a paper system to an electronic system, including electronic filings, one county at a time. And I think as I recall, they say Baltimore City for last because it was the biggest and most. So it's just coming online. Okay, that's what I thought. I thought it was this year, sometime this year. So they will finally, after what, 20 years maybe, be online with a brand new system. So my concern is through this language, we might inadvertently be requiring them to declare the system obsolete quickly and try to replace this entire system, which has taken them 20 years to adopt. And heavens knows how much expense and logistical problems. I would feel more comfortable with this if we could get someone from the judiciary in here to take a look at this language and tell us whether or not, in fact, that would happen, or whether they're happy to go forward with this language.
Senator Carter, do you have a motion? Have we adopted the amendment? Sorry, excuse me, my apologies. Let's adopt the amendment. It's okay to adopt the amendment. Okay, now the bill's before you as amended. Senator Carter, do you have a motion?
Move favorable bill. Second.
Roll call with amendment.
Vice Chair Waldstreicher.
Yes.
Senator Sudnor.
Yes.
Senator West.
Sometimes bad decisions are made in a rush. No.
Senator Muse.
Yes.
Senator Folden.
No.
Senator James.
I don't want to do, I just want to pass for a minute because I am so not familiar with this area. So I'm just.
Senator Charles,
Yes.
Senator Kelly,
Yes.
Senator McKay,
Yes.
Senator Carter.
Because 20 years is not a rush, and Martin Luther King said, why we can't wait? Yes.
Senator James, whenever you're ready.
Okay, can I ask a quick question of Senator Carter? Senator Carter, can you familiarize me with something? So apologize for not understanding this. So what, right now, can you get your charges without, if, putting aside this mess, can you generally get charges expunged, assuming that it's not messed up like this situation? Can you just do that in general?
So we allow
Right?
all charges that do not result in a conviction or or PBJ after some time to be expunged.
Expunged.
This category of non-convictions is not expungible simply because they are charged in conjunction with other charges, and there could be another charge. So like say there's 10 charges in an indictment or 10 charges in a statement of charges.
Yeah.
1 is a conviction, 9 are non-convictions. The 9 non-convictions are not expungible.
Oh, but that's because not a policy decision, but because of the inability of the judiciary to have the kind of computer capacity to go in and, you know.
Well, I believe
noodle
the
around in there.
state's attorneys, some of them would like to make it a policy decision, but it is not a policy
But
decision.
just to confirm again, Senator Carter, if you didn't have that situation with those lesser, larger charges, let's just say you were just charged, and let's say you didn't get convicted on anything, you could, in that circumstance, go to and get that expunged after.
Under
a
current
certain-
law, they're already automatically. We allow non-convictions to be now null process and not guilties and non-convictions to be automatically expunged.
So even the person doesn't even have to apply for it? Is that what you're saying? They're just automatic? Or do you have?
We've passed law
I
over,
just want to
under,
understand
I
how
think
it
it's up for
works.
debate, but
Not guilty
Yeah,
verdict.
yeah.
It is now automatically expunged.
Okay.
Just a quick clarification
Oh,
though.
that,
The unit rule applies to non-convictions. Senator Carter's exactly right, but it also applies to convictions of actual offenses that are expungible. So just to be clear, we're dealing with 2 different things:
yeah, I'm,
expungable non-convictions and expungable convictions.
and the reason for that's true. And the reason is because when we started with this bill,
Yeah.
there weren't convictions that were expungible. So there was initially just a non-conviction bill, but you're right. Since that time, we've now allowed certain convictions to be expunged.
all right. And with all that in mind, yes.
Thank you.
Chairman Smith,
Yes. Bill passes 9-2 with amendment. All right. All right, so we're gonna do, so Pom said, yeah. All right, we're just gonna wait for a second, okay? So, all right, Senate Bill 190, and then we're gonna go to, we're
That's me seeing.
yeah, then 1098, which is also you, and then the last bill we're doing is the Senator Carter's bill, okay? We're gonna do 1, 2, 3 is the last bill we're doing before we go back to the floor. All right, Senator Carter, you have something?
So Senate Bill 190 requires a law enforcement agency that receives a qualified request for a wellness check of an individual to immediately conduct a wellness check of the individual if the individual is located in the law enforcement agency's jurisdiction, or submit a request to the relevant law enforcement agency in the state or another state to conduct a wellness check if the individual is not located in the law enforcement agency's jurisdiction. A law enforcement agency that receives a qualified request must meet these requirements regardless of where the individual or entity making the qualified request is located. There is one amendment in your voting packet. It is Amendment 373-121/1. That is Senate Bill 190, Amendment 373-121/1. The amendment provides that a qualified request is one that in addition to what's specified in the bill as drafted, is one made in a manner or includes sufficient information to allow a law enforcement agency to respond to the person making the request. The amendment requires that instead of being required to immediately conduct a wellness check, where the person for whom the check is requested within the jurisdiction of the law enforcement agency, the check must be done within a reasonable amount of time after receiving the request. For a person who is outside of the law enforcement agency's jurisdiction, the agency must promptly provide the person making the request with contact information for the law enforcement agency which does have jurisdiction. A law enforcement agency is not required to conduct a wellness check if any of the following are present. The agency reasonably believes that the individual for whom the check is requested is not in physical danger and is not physically injured. 2, unless the agency believes that the individual is in physical danger or injured, the agency reasonably believes that conducting a wellness check will bother, harass, intimidate, or torment the individual. Or 3, the individual has requested that the law enforcement agency not conduct wellness checks on the individual in response to requests to do so. Additionally, the amendment provides that the bill's provisions do not create a cause of action against a law enforcement agency, its employees, or its agents for a failure to conduct a wellness check in accordance with the bill's provisions, and that failure of a law enforcement agency to comply with the bill's provisions may not be used as evidence of negligence or recklessness in a civil suit against the agency, its employees, or its agents.
I'm sorry. One additional amendment that's going to be just drawn up, and that was to change it to Gabriel's law. Okay.
I think so. Senator.
Concerns, questions?
Where are we on this bill?
Yeah. But I just read in Senator Muse's amendment to change the bill's name to Gabriel's Law.
Are you okay with that?
Yes.
All right, let's move the amendments. Is everyone okay to adopt the amendments? Now the bill's before you as amended. Motions for favorable.
With
Same.
amendment.
With amendment. Everyone's okay being recorded in the affirmative? All right, Senate Bill 190 passes with amendments unanimously. We're now going to go on to Senate Bill 1098. Jamie.
Senate Bill 1098 prohibits an incarcerated individual who is serving a sentence for first-degree rape that occurred on or after October 1, 2024 in a state or local correctional facility from earning diminution credits to reduce the individual's term of confinement. So under current law, you're only prohibited if your victim was under the age of 16.
Thoughts about the bill?
Outside of this one incident that I think we all can agree is horrific, I'm always I'm wondering how many times that somebody in this instance has done something like this. So because of this one man did what he did, we're going to change the law in effect. How many other people, do we have any idea how many people are incarcerated that would be affected by this?
Yes, so according to the fiscal note, DOC reports an average of 14 individuals annually convicted of first-degree rape with an average sentence of 26 years. So that would be the population affected by the bill, assuming that if the victim was under 16 in any of those cases, they would already be prohibited. But for any of those people who were convicted of first-degree rape of an individual over the age of 16, that would be the population that would now be affected by the bill.
And just to be clear, I guess under this bill, they would be ineligible for diminution credits, but still eligible, to go front for parole? And how long before they would be eligible for that, generally speaking?
Yeah, half of the sentence.
All right, thank you.
All right, there's been a motion for favorable. It's been seconded. Let's do a roll call.
Hold it back for 2 seconds.
Yep, of course.
Does the bill do? What offenses does it address?
So it prohibits anyone convicted of first degree rape from receiving diminution credits.
Would they now be the only people in the world that would not get them?
So currently it's first or second degree rape if your victim is under 16, or multiple third degree offenses if all the victims were under 16. So it would be, under the bill, it would be all first degree rape, second degree rape of a victim under 16, and anyone who's been convicted of multiple third degree sex offenses with victims under 16.
So really quickly, I promise not to believe this because I want to get to my bill. I understand why one would want them not to have them credits. I get it. Like, they did a terrible thing. We're guessing they're probably not capable of being rehabilitated. They're a threat to public safety. We want to make a strong point. But my question becomes, what is their incentive to be a better inmate or a better person? Like, why would they then avail themselves of anything?
And also, yeah, apart from parole, it's, a lot of those activities allow you to get out and about. I mean, the testimony was that a lot of the activities, not only the enriching, but it allows you time outside of your cell and away from the kind of monotony of your service. But we're going to do a roll call because I'd like to get on to the next bill.
Vice Chair Waldstraker,
Yes.
Senator Sidnor,
Pass.
Senator West,
Yes.
Senator Muse,
Pass.
Senator Folden,
Yes.
Senator James,
Yes.
Senator Charles,
Yes.
Senator Kelly,
Oh, yes.
Senator McKay,
Yes.
Senator Carter.
I got no lifelines here. Yes, I'm gonna vote for the bill, even though I don't agree with the policy. And I think that, can I say another thing real quick? I voted for the bill.
Yep.
Okay, I'm just gonna go ahead and vote for the bill, but let me just tell you, there was a lot more to that one case than met the eye, and so many other layers of problems with the way that law enforcement handled that situation. I mean, we do these reactionary things and that's fine, but we got to dig a little deeper into situations like why the Baltimore police refused to investigate or pursue the culprit once he had set on fire and sexually abused a Black woman just like a week before. Just saying.
Not only that, but if, like we said, I know the sentence was reduced in half in this one case, which is not the driver of this bill, but I know, and it's, look, the sentence was reduced in half. And then also the dim credits that he must have hit every wicket, but apparently that wasn't the case. So there is definitely something else there. So, anyway, this is no, hold on. Senator Sidnor has a vote.
Senator Sidnor?
Yes.
All right,
Oh,
the
wait,
bill,
one more vote.
whose
Senator
vote?
Muse.
Senator Muse. Oh, sorry.
Senator Muse.
No.
Chairman
Yeah.
Smith.
Yeah. Go. And,
Chairman Smith.
I'm gonna vote yes. Hold on, just the votes. Let me clear this vote off the table. Then I'm gonna give you an opportunity to speak. You want to be on the bill?
It's
Okay.
favorable, so it's not favorable with amendment.
Favorable, straight up favorable. There's gonna be an amendment. An amendment will make it subject to layover, just an FYI.
Okay.
Okay, so. No.
So I just want to clear something up here. I don't necessarily, I don't want this to be something that gets pointed back towards law enforcement's responsibility to do their job better when someone got burned. The actual issue is that the man burned somebody and raped her. Like, law enforcement can only respond with the tools they're given. So to say that somehow the law enforcement should have done their job better because they have such clairvoyance that they should have known, I just wholly disagree.
Or he
Yeah.
committed this crime. And had
I
they,
understand.
with any zealousness, pursued the man for that crime, this probably wouldn't have happened. Or even, they could
They-
even put out the information to the community about it. And
Okay.
really quick, look,
Okay.
and when asked about it, the current police commissioner responded
Yeah.
that he didn't want to say anything negative about victims, but they knew each other. There was a relationship. It was a complete lie. They did come back and retract later. So yeah, it was a lot more to this.
Also just say, forget, I hear what you're both saying, but what, just facts again, like the sentence was a little interesting.
Yes.
And then the fact that the person got out so quickly was fascinating. And
But the idea
I
was-
wonder aloud if there was problem with the paperwork or calculating dim credits, because something odd happened. And I think we should all take a look into that. And I look forward to looking into that with this committee.
But the idea to put that on law enforcement
I'm not
after the
putting-
person was
no.
burned and raped, is.
That's not on,
It's
that's
not
not
relevant
No,
to
that's
this.
not what I'm saying. Yeah,
It's not what you're saying. That's not relevant to this.
yeah.
Well, it's just wasn't, it's not a part of this. It's not a part of this hearing. It's not a part of this hearing. It's not relevant to this. This hearing is about dim credits.
All right,
So,
let's get going on to the next bill with
Okay, remember that next time, bring up the state's attorney with our legislative bill.
Senate Bill 123. One, two, three.
Senate Bill 123 allows an individual to file a petition to reduce a sentence if the individual has served at least 20 years of the term of confinement. At least 3 years have passed since the court decided any previous petition filed by the individual under the bill. After consideration of certain factors and a hearing, the court may reduce the petitioner's sentence if it finds that the individual is not a danger to the public and the interest of justice will be better served by a reduced sentence. There is a rebuttable presumption that a petitioner is not a danger to the public if the petitioner is at least age 60 and has been confined for 30 years or more. A court may not increase a petitioner's sentence, and the right to seek a sentence reduction may not be waived. The bill establishes additional procedural requirements. There is an amendment that's currently being drafted. We don't have it. Senator West, did you want to offer as or I can explain the conceptual? Okay. And, please correct me if there's anything. Senator West's amendment, would be, to limit a petitioner to, 2 opportunities, to petition under the bill's provisions, at most, but at least one. So a person would first be able to petition the earlier of 20 years or the defendant's 60th birthday, or after the defendant's 60th birthday. However, a second opportunity would only be afforded to a person who had filed after 20 years of imprisonment. They may file again at or after age 60.
You have to do 20?
You have to be at least 20 in.
Sorry, you have to do 20 under any of those circumstances.
That's right.
Right.
Okay, all right.
The bill currently provides for regarding someone 30 years and 60. So that's.
$30 years?
No. It's 20 years.
Right.
Or someone 60 that's done 30 years.
Right. So the amendment effectively takes out the ability of someone to, if they don't succeed after 20 years, to come back 3 years later, and then 3 years later, and 3 years later. Those are withdrawn. So you can apply after 20 years, and then you have a second bite at the apple when you're 60 years old. And I think what Jamie was talking about is if you get sentenced late in life, so that your 20 years doesn't run until you're after 60, you only get one bite at the apple, and that's after the 20 years. Because by that time you'd be older than 60. See what I'm saying?
I see what you're saying.
Okay.
So let me ask Jamie a question. Does that override the section of the bill that says that an individual that's served 30 years or more, or that is 60 years of age or older, that provision, that remains in the bill, or that overrides the bill?
Well, so my read of the bill, and I can pull up the language, Senator, but
And I'm not arguing, I just want to be clear.
My read of the bill is that that's not actually the at least 60 and has served 30 isn't applicable to their being able to file a petition, but it is applicable to
The
a court's
standard, okay.
finding, right?
Well, then in that case,
It's a
that's fine.
presumption that they're not a danger.
Got it. Okay, I'm good.
Senator West, you move your amendment?
Yes.
Second, do we need a roll call? All right, now everyone's okay adopting the amendment. Now the bill is before you as amended. Motions for or favorable. Can I get Senator James?
Senator Carter, is this for any crime? Just so I'm sorry, this is for you, so if you murdered 5 people, you could do this. If you raped 10 women, you could still do this. Is that correct? Is that how the bill works? Okay, thank you.
Opportunity to file a motion, most likely, since the nature of the crime is one of the considerations, that would definitely weigh very heavily on a decision, and judges are not really scared to deny these kinds of things, I would just say.
I just want to make sure not marked as a no on that amendment.
Vice Chair Waldstraker,
Yes.
Senator Sidnor,
Yes.
Senator West,
Yes.
Senator Muse,
Yes.
Senator Folden,
No.
Senator James,
I'm gonna pass and read one more thing about the bill.
Senator Charles,
Yes.
Senator Kelly,
Yes.
Senator McKay,
Yes.
Senator Carter,
Yes.
Senator James, when you're ready.
Okay, thank you very much. A little late for me to ask questions, so since I don't understand the bill, my answer is no. That's all.
Chairman Smith.
Yes. Senate Bill 123 with amendment passes 9-2. All right, that concludes our voting session. See you on the floor.